the first estate planning mistake is the failure to have a current updated last will and testament stating who will receive your property and who will be appointed guardian to take care of your minor children. Clients are often surprised when I tell them, it's fine if you don't want to have a will, but the state does have a will for you, and you may not like what the state provides. If you die without a will, each state has laws of intestacy, which basically states who will receive your property upon your death. And for instance, in Kentucky, if you die without a will and you don't have beneficiary designations on your assets and everything passes under probate, Kentucky law says half goes to your spouse, half goes to your children. Well, if your spouse is the parent of your children, typically you want to leave everything to your spouse, and your children aren't going to receive anything until after your spouse passes away. So it's very important in Kentucky to have a will. In Ohio, Ohio does it a little differently because they try and account for blended families, that if you have children from a prior relationship, making sure those children are not excluded. So Ohio does a calculation, but unfortunately I have seen at times where what you wanted the state law would not be good for what you wanted. I currently have an estate right now that I'm administering that the decedent died without a will. She was never married, she never had any children, and her 3 beneficiaries are her 3 siblings, which doesn't sound bad, you know, to leave it to your 3 siblings, except for the fact that 2 of the siblings are incompetent, living in nursing homes on Medicaid, and basically their inheritance, once they get their inheritance, they're going to be able to prepay their funeral expenses, and then everything else is going to go to the nursing home. So basically 2/3 of this woman's inheritance is going to nursing home care, and these people will get kicked off of Medicaid. They'll have to spend this money down, and once it's gone, then they'll go back on Medicaid. Had I met with this woman, I did not know her while she was living, I would have advised her to, instead of leaving it to siblings, leave it to those siblings' children so that they could have used that money to supplement mom and dad's care. So sometimes it doesn't turn out the way that probably the person would have wanted it to. I had another case recently where a gentleman had a longtime girlfriend, and so I said, well, do you have a will? Yes, I have a will. Can I see the will? The will was not valid because it was only witnessed by 1 person, and to have a valid will in Ohio, it has to be witnessed by 2 people. So if he actually has had some health issues lately that he actually didn't think he was going to live. And so we quickly did a new will, because if he would have died with the will that he had, his girlfriend would not have received the assets. It would have went to 2 nieces and nephews that he hasn't spoken to in years. So that was a case where we were able to quickly do something, but it doesn't always work out like that. The other reason why you need a will is that if you have minor children, the will is where you specify who's going to raise your minor children if something happened to you and your spouse or the parent of that child. And again, I've seen instances where the wrong people come forward, because ultimately what happens is if a guardian needs to be appointed, the probate court has the ultimate say as to who that guardian will be. So if you have named a guardian in your will, as long as that person is a fit person, they don't have a drug, alcohol, or domestic violence issues, the court will defer to your choice. But if you haven't specified who should be the guardian, then the court has to decide. And family is going to take priority, and you may or may not want family to be the guardian, or you may want a certain family member as opposed to another family member. I had a client last summer who was terminal, and her husband had already predeceased her, and she had 3 minor children that she wanted very good friends to raise. So we did a will to make sure that if something happens to her, that friends are going to raise the children, friends who live in Cincinnati, as opposed to family members that live in another state. She feels it would be traumatic for her children to have to move. So it's just important, we never think that we're going to die, but it's important to think about these issues, especially if you have minor children, and wanting to ensure that they're raised by the people that you want them to be raised.